And welcome to the Trill MBA Show. I'm your host, the trillest MBA you will ever know. And I'm here to help you survive and thrive in corporate America by giving you the truth and being as real as only I can be. Well, guys, I'm happy that you're tuning into the show today because with the recent results of the Women in the Workplace study by McKinsey and leanin.org, confirming that once again, African American women endure the worst treatment in the workplace. And then, according to the 2018 State of Women-Owned Business Report, commissioned by American Express, in the past 10 years, the number of firms owned by Black women grew by a stunning 164%, nearly 3 times the growth rate of women-owned businesses during the same time frame. So, what does this mean? Well, whether you are hanging in there to fight the good fight in corporate America, which I'm cheering all you guys on to do, or you're tired of the BS treatment and you're striking out on your own, either via side hustle or full-time business venture, one thing is very clear. You need to know your rights and you need to know the law. And so today, ladies, I have a very special guest in studio, Mike Coles. Mike Coles is an attorney with the Coles firm based in Dallas, Texas. He has over 20 years of experience representing employees and employers in a wide variety of employment law and business matters. He received his bachelor's and law degrees from Duke University before moving to Texas to begin his legal career. In addition to representing employers and employees, he is also a certified mediator and is regularly appointed by the judges of Dallas County to mediate cases. Mike, welcome to the show.
Thank you.
I'm so happy to have you here because I have so many friends going through all kinds of crazy things. So today, I really just want you to impart all the knowledge you can within the next hour to my listeners.
Absolutely.
But first, I want you to tell me what drives your passion around helping people understand their rights from a legal perspective.
Yeah, that's an interesting question. Sort of how did I get into this in the first place? And I actually knew that I wanted to be a lawyer when I was 16 years old.
Wow.
And so I actually participated in one of those high school mock trial programs.
Oh, cool.
And by the time the season was over, it was a done deal. Mm-hmm. So I knew that's what I wanted to do, but I only knew that far. I had no idea what I wanted to do with the practice of law.
Okay.
And it wasn't until I was actually in college that I had some experiences where I felt like having an advocate would be so much more beneficial for me. Mm-hmm. Instead of trying to navigate that process independently.
Right.
And so learning that that kind of resource was valuable, and then more importantly, recognizing that in my background, my family history, we had no legal experience or expertise to look to or lean on. Mm-hmm. And so that's probably the case, is what I understood, for a lot of my peers. They don't have that kind of a resource to lean on. And so how do we create that resource within a community? Someone has to do it. Someone has to be the one that's there and available to be able to say, how can I help?
And so you decided to be that one.
That's right. I mean, I'm certainly not the only one out there. I'm not the Lone Ranger. So there are others that are doing as much as they can as well. But certainly, when you ask who's going to help, the first question should be, why not me?
God bless you, because I have worked with a number of attorneys in my post-MBA career now, and it just seems like a lot. I have friends that are attorneys, and the law is so nuanced, and every individual situation is different. And so you really need an expert to guide you through your individual situation. But one thing I think so many Black women are missing when it comes to this aspect of their career, and I mentioned at the top of the show about the Women in the Workplace study that McKinsey and LeanIn.org did. And
Right.
in that study, it talks about how managers are mistreating their employees, their Black women employees specifically. And I want to understand off top, before you even get a job, what advice do you have for anyone going out into a career when it comes to looking for counsel? Like from applying to jobs to getting an offer to leaving your company to go to another company. Like what are the top 2 general things that women should be thinking about, or my listeners rather should be thinking about?
So when you look at getting counsel, the thing about being a lawyer is that job security relies on you creating a mystery around the service that you provide. The more you think you can't go without me, the more job security I have.
Okay.
So when you think about who are you going to work with, find someone that's actually willing to peel back the curtain and let you see behind that mysterious panel. Right? Because if they're not willing to go arm in arm with you as a partner, if they're looking at how can I maintain the economic benefits on my side of the table, that's not a true counselor. That's a service provider who is not looking out for your best interest.
I'm so glad you said that, because I recently ran into a situation with someone that at the end of the day, they didn't help me because they were worried about the risk model. And I was like, no, that's not the point of what's happening here. And so without going into too many details, I realized that I learned that the hard way. So I'm very glad that you brought that up. When people are looking for help, they need somebody who's going to partner with them and be hand in hand and really think offensively, and not just like, oh, you're going to lose because X, Y, or Z. You need to be like, oh, they're going to do this, but we can do A, B, C. And that's important. So I'm glad you said that. That is a key nugget.
That's right. And let me add one more thing to that, which is all too often when we talk about winning and losing, and I'm going to go back to when I was a kid, and you probably hear this today, that little kids are being told, you should be a lawyer because you like to argue. And
Yes.
That's doing both the child and the profession a disservice, because I would much rather hear, oh, you like to problem solve. You should be a lawyer. Because at the end of the day, that's what's really happening. If you come into my office and say, I have this problem at work, and I think to myself, well, we can only do one thing, and that's sue them, right? Let's sue the bastards.
Right.
That approach isn't really problem solving. It's basically saying, I only have a hammer, and so every problem needs a hammer.
Yeah, and that's not true.
It's not true.
Yeah. And I'm glad you brought that up, because again, I feel like I just learned that lesson. I wish we had talked like in February. That is when I needed to talk to you. So one thing you're very passionate about is you talk to a lot of different professionals, business owners, about the 5 myths of employment contracts. And so I'm really excited about this, because I know when we were discussing this earlier, I realized like, oh, yeah, I've believed all those things. Like I just never knew, which is good that I'm smart enough to know when I don't know and to get help. So right now I want you to go through and talk about these 5 myths that a lot of us out here in corporate, we believe about contracts and the agreements that we make with our employers.
Right.
So thank you for sharing this with my listeners up front, because this is the stuff, ladies, we need to know.
That's right. I mean, right out of the gate, when you get that document slid across the table or in an email from HR or even a recruiter, there's a certain amount of excitement, jubilation. You've got the job. And you've got to temper that enthusiasm with the understanding that this is the first round of the discussion. This is the first round of the negotiation. And the question is always, what is the power dynamic? Does the employer need the employee more than the employee needs the employer? Right? If you have a job, whether you like that job or not, they certainly don't know that. And
Right.
so you're able to convey to the employer, I'm leaving a secure position. I'm leaving an environment that is known to me, and I am going into an unknown. And I am looking for you to make that jump enticing and worth my while, because I am taking on a certain measure of risk. And so making sure that the employer has that in mind, and then you can say things where, maybe the salary range is there. There are so many cases that I've been involved in that are actual litigation matters about salary being unfair, where particularly women of color are not being given the salary that they're due and that's commensurate with the skills that they bring to the table. There's this notion of proving yourself and coming in
Right.
and having to earn that extra money. And then you look to your left or right and you see that other person did not have to
Right.
come to the table with the skills and education or experience that you brought, or they did not have to earn that additional income. That's a very real event in corporate America.
Oh no, that's happened to me. And probably ladies, if you're not driving, raise your hand, say a hallelujah if this has happened to you. And I guarantee you it's every single one of my listeners, including myself.
And so that's why you have to start with the understanding that this is the first round of discussion.
Okay.
Now, to the extent you don't have a job, to the extent you need this job, it might be just one of 2 rounds of discussion. You might not have the
Right.
luxury of having the negotiation be sort of a protracted
Right.
process. But if you have any measure of leverage, now is the time to exercise that right at the very beginning, because it sets the table for what happens from here on out. Remember, right, when you give up what you think is just a few $1,000s, merit increases are often a percentage.
Exactly.
And so you're giving up that same money every time you come around for an annual review, right?
Preach.
So you have to be aware that you're starting a process, and you can't level set downstream without some really hard effort that's already been undertaken. You've been there for 1, 2, 3 years, and you're trying to say, I need catch-up money.
Right.
That's a harder conversation because they already have you in-house.
Right. Oh my God. I'm so glad you said that. So one thing I think we have in our minds is that when we get the offer, we'll lose it if we try to negotiate.
That's right. And it's a stylistic question. There is a way to have a good, positive discussion because the person on the other end is probably having that same discussion with someone on the other side of the table from them. They get it. They understand. Tone, style, how you engage is all about really understanding their perspective and presenting your issues with a framework that they understand.
And I think that when we talk about that framework, you really need to lean into data that you find salary.com, Glassdoor, what are the ranges for that role? Go look at the competitors of this company and see what they're paying the same type of role for the same type of role, and create your argument based on that data.
That's right. And because I'm talking about the beginning of the relationship, there's no substitute for letting them know you do your research. When you go in for your interview, they want to know that you've researched the company.
Right.
When you accept the job, you want to show that you researched the position just the same.
Right. Exactly. Oh, praise God. I'm having all kinds of hallelujah. Thank you, Jesus. I'm so glad this is happening right now because we're at a point in the country where there are actually more jobs than there are unemployed people. So this is actually an employee's market.
That's right.
And so you need to really be smart. And we already know that we shouldn't stay in jobs for more than 5 years because that's when you start losing money. And it is literally okay now to not be at a company for 20 years. Like it's not even expected anymore. Recruiters will call you every day, even though you've been in a company for 6 months.
Yeah.
They'll call you at work. And so with that, ladies, this is the time not to be afraid. This is the time to secure the bag.
Well, and if you think about it, you've got 40 years of working life is what is anticipated for the average adult.
Right.
How many of those years are you giving up in terms of financial opportunities when you start by not negotiating on the front side? Because keeping in mind, the next job is going to ask you, what was your salary at the last job?
Exactly.
And you're just compounding this one-time decision, you think.
Mm-hmm.
And ultimately, the economic impact over the course of 40 years is a significant sum.
Right. Ladies, you really gotta get courageous. And we've talked about this on previous episodes I've had about us having the courage to speak up for ourselves. We are professional. There's no reason to be afraid to go in and state your case. So one of the things that you also mentioned in these 5 myths of employment contracts is that non-competes some people think they aren't enforceable. Some people think, oh, that's just, you know, something. So what's the real deal? Like, if I go to my company's competitor, could they really come after me?
So there's 2 things to keep in mind. The first is absolutely, yes, they are enforceable.
Oh.
And so that is, now each state has its own laws regarding enforcing a non-compete. And so you need to be clear, where is it that this non-compete is going to be enforced? And so I'll take Texas as an example.
Mm-hmm.
Texas in the 90s was very much an individual liberty kind of state. And so non-competes were not enforceable. We had a law on the books, and the courts read that law and said they're very hard to enforce, and they made you do a lot of work to enforce them. And then suddenly, Texas became a business-friendly state. The law didn't change.
Right.
The words on the page remained the same. And the courts basically said, you know what? This is good for business. This is good for Texas. These are now far more enforceable. And so be clear. And this is important when you are actually looking at 2 things. One, when you have a sales role, especially that covers a multi-state region. And number 2, when you transition from one location to the next, which is a change from one state to the next, the laws will be different potentially. And so you've got to be clear, what is the law that applies to me here versus there?
So one situation I found myself in at one point is when I left one company and went to their direct competitor, which I thought was cool. But now that I think about it, the funny thing is I had no idea if I had signed any type of non-compete or anything. Now, for me, the good thing is the type of work that I do in corporate America, it's not like a sales role. In marketing, we all do the same kind of thing, especially when you're working on brand equity work. It's the same base skill. So it's not like you're doing anything proprietary.
Right.
That if you go to the competitor, I mean, all they do is kick you out that day if you tell them, I'm going to your direct competitor. They're like, oh, give me your computer, you got to go. But at that point, I've already downloaded everything I wanted because I knew I was leaving. So, but I had sat there and I asked myself, like, did I sign anything? And I had no clue. And I had no documents. I didn't know. Yeah. And I didn't even know, like, should I go to HR and ask? And what should I have done when I started working for company A in the beginning?
Today, cloud storage is not just cheap, it's free.
Right.
Okay. So there are a number of different resources you can use that will give you a relatively low, but for these purposes, very large cloud storage account. Store all of your key documents there. Okay. Your offer letter, whatever contracts you get, any of the documents, your employee review.
Okay. Right.
In the days of having a file cabinet, or even I used to have a box that I could tote around and have all my Documents there, that's over. That's
Yeah.
gone. Cloud storage is the way to go, because the next thing that happens is when you have a new employer, and this happens where my clients on the employer side will call me and say, I want to hire employee X. And here comes Jane Smith in the door, and their first question is, do you have a non-compete? And then when the employee says, I don't know, or I don't have it, that derails the conversation. They're much happier to say, we've got a lawyer. His name is Mike Coles. You send me your current agreement. I send it to him, and he can tell me if we can hire you. And you can move that conversation along much quicker.
Okay.
Because what you don't want to do is, if the employer has no clue where you are currently working, that you're in the market, how can you go to HR and ask for your non-compete without sending up some serious red flags?
Right.
So you're in a box here. You can't get it, but the new place won't hire you until they've seen it. And so now what? Well, cloud storage. Store it, keep it. It's there forever. You don't have to worry about it.
So before you sign your offer letter with the company, you should make sure that you understand what's in that letter and not just look at the salary.
That's right. You have to do that. Too many people think the salary is the thing, and they said they were going to pay me X. That number is on this page. Great. Right. And there's just so many little things that come up over the course of your employment, and often at the end. And my clients consistently don't know. Did you sign an arbitration agreement with your last position there? They have no idea. Did you sign a work for hire document that says that things that you created are actually going to belong to the employer when you leave? They don't know. And so suddenly this uncertainty can have significant problems. You talk about a side hustle. What would happen if your side hustle became your employer's hustle?
Because you were working there.
That's right. You didn't protect what you were doing outside of work hours. And so now the argument is, you signed a document that says that they own what you built if it has anything to do with anything in their business model. And suddenly you think you're leaving to go start your business full time, and they find out about it and they say, that's ours.
Oh my God. I know I don't think about that. I mean, even with my current situation. So I've started this media company. I have a podcast. The cool thing is I do know that chips and podcasts really don't have much to do with each other right now. So I dare them.
Right. If you can stay far enough away, you may have some comfort.
Right.
But a lot of us have ideas when we're sitting at work and we see a problem that could be solved.
Right.
And now what?
Oh, man. Big aha that I'm having right in this moment is that I just need to be lawyered up. Like, I should just keep a lawyer on retainer.
And it's cost prohibitive in a lot of people's minds, but it actually isn't. Because having a lawyer on retainer is not necessarily an ongoing cost. What you really want is a lawyer who will take your call when something comes up. And so this happened to me yesterday.
Okay.
I was in a deposition out in East Texas, and we didn't wrap up until the end of the day.
Okay.
But over the course of the day, I got 2 emails from a guy that I've known since 1998.
Oh, wow.
All right. But I haven't talked to him since probably 2008 or
Oh,
so.
10 years.
All right. So we hadn't talked, but his name comes up in my email. He says, hey, do you have time to talk? But I'm in a deposition. He sends me a second email at the end of the day. Hey, I know you're busy, but I really need to talk. I still have his cell phone number. So I get in my car and I call him from the road driving back to Dallas from East Texas. And so that's what he values, is when I need a guy, I get that guy.
Right.
And I might not get him the second that I want.
Well, right.
But in a reasonable amount of time, that guy can reach out and say, hey, I have your phone number. I can call you at home. I can call your cell. I can text you, because of a relationship that goes back decades.
Okay.
And he hadn't paid me a dime in 10 years, just about. And that's okay.
Right. He's good for it.
Right.
So when we're looking for a partnership, that's what we want to look for.
That's right. Someone that will be available, but also know what's going on in your life at a certain level.
Okay.
And then listen to what's changed since the last time.
Okay.
Right. And so I had one client who I represented in a case after they left their prior employer. We litigated the case. The case worked out fine. They were happy. They moved on. Years later, they're now starting a business with a husband, and they call up and say, hey, I don't even know if you can do this, but if you can help me with this, let's keep going. And it's just a certain amount of familiarity, right? That just helps you when you have an issue that needs to be addressed right now. That familiarity goes a long way.
Okay. Now, the third thing that you say in these 5 myths of employment contracts is a contract by definition isn't necessarily written on paper.
That's right.
So oral contracts are a real thing. Like, that's not just something we see on law shows on TV. Like,
you can form an oral agreement, and I will take it one step further. Every employee at every job in America has a contract.
But Texas is an at-will state. So how does that work?
So you can have a written contract that is an at-will contract. The at-will question, and to be clear about what at-will means, that means you can quit anytime, you can be fired anytime.
Right.
All right. The fact that it is at-will has nothing to do with whether or not it's enforceable or if it's in writing or if it's oral. When I say to you, think of it this way. You get your first job, you're in high school, and you're going to go get a job at the mall.
Right.
All right. And so there you are, and you're selling whatever it is that you're selling at the mall. And you think, well, I don't have an employment contract. Yes, you do. You have a contract that says if you work X hours, I will pay you Y dollars per hour. Now, that Y dollars might be minimum wage, but it is still a contractual obligation to pay you as you've worked those hours. And that contract is enforceable. That is at the lowest level of an employment relationship that you could imagine, right? Is this high schooler who's working a minimum wage job.
Right. And so in that example, if the employer fails to pay them when they agreed to pay them, then that's where there's a breach of contract.
That's right. And I have filed more than one lawsuit alleging breach of contract on an oral agreement and happily proceed with that lawsuit.
Okay. Wow. So take notice of not just what's in writing, but also what's said to you.
But don't be convinced that what was said, this happens sometimes, they will say in a document, standard vacation 2 weeks per year. But don't worry, we don't really enforce that. Or we'll give you 3 weeks. Or they'll say something to you to that effect. What's in writing is going to hold.
Okay.
All right.
That's
so
fair.
Don't believe that you can come in with an oral modification and successfully change the written document.
So for my audience, I think what's important to note, a lot of times we have salary jobs that don't necessarily track vacation. And so I would say a big watch out for us is you monitor your vacation so that you know what's in writing. So you know that they gave you 3 weeks vacation in writing. And you make sure that you protect yourself so your boss can't come back and be like, I think that you've been out of the office too much. Or
that's right.
I think that blah, blah, you know how they are.
Right.
And so
nothing's a problem until I say it's a problem.
Exactly. And so even though they don't track the vacation or there's no formal system, you, to protect yourself, still need to be aware of what you've agreed to.
That's right.
Nuggets, ladies, nuggets. We also talked about how we see the salary in a document, but you're telling me that that's not the most important thing in the document?
No, when you think about that new position and you think what they're going to pay you, oddly enough, that's the easiest thing for us to get enforced with or without an agreement, right?
Right.
That's the one thing they give you.
Right.
What are you giving them? That is far more important to you.
I never thought about it that way.
And you are often giving up. You could be giving up the right to a jury trial. You could be giving up the right to even go to court at all with an arbitration. You could be giving up your right to compete at another job. You could be giving up literally these rights. Like, for example, courts have said, if you talk about going to the EEOC when you have a problem.
Right.
And so typically you get 300 days.
Right.
Courts are actually looking and saying that the employer can actually change the requirements on how soon you can file a lawsuit. So certain lawsuits you might be able to file within 2 years or 4 years. And there are waivers that say you must file it within 6 months in your documents.
Wow.
And so Congress or your state legislature has determined that you get this many years and you've lost over half of that time because you signed an agreement that committed you to raising a complaint within a smaller window of time.
So this is why we can't get excited when we see, oh, they're going to pay me this much. And my biggest pain point has always been, you see that number, you're excited because it's more than what you thought you were going to get. And so you just rush to sign, yes, I'm going to start the new job. I got my start date. I'm good to go. And you haven't even looked at what you've agreed to. You just looking at the money.
Yeah, get excited, but then get educated.
Yes, which is another reason why you need counsel.
That's right.
And so the last myth you have here, which I'm guilty. I've never ever done now what I know I'm supposed to do. But I've always signed on the dotted line. I agree. Now, I do read, but I don't read through everything. So that's on me. And I sign and I start, but then I never get any documents back.
That's right. The countersigned document. That's right.
I didn't even know there was a countersigned document. So how many of y'all know it's a countersigned document?
Yeah.
I didn't.
You've got to get it back because, and I've had two things, and I'll tell you a story which was interesting. One of my very, very first cases, I had a situation where I was representing an employer, and the employer wanted to enforce a non-compete against a former employee. So I march into the courthouse with the signed contract that this employee signed and said, "Judge, here's the contract. He signed it. Enforce it." That employee said, here's what I actually signed. What the employer did is basically lose the first few pages because they only kept the signature page. And then they matched the signature page against the current document because the person who was doing it had no clue that the document had changed over time. So I was handed a document that looked internally consistent, and it was absolutely not.
Wow.
And the employee who kept his records produced the actual document, and that turned the outcome of the case.
Wow.
And so if you don't have that document, and you better believe it needs to be signed by the employer, because the rule is, if you're enforcing it against me, the only signature that really matters is mine.
Wow. So how do we go about asking? So you sign it and then you send a note to the HR person you're working with and you say, can I get the countersign back? Is that simple?
It's that simple.
Okay. And there shouldn't be any issues, right? Like they should know that people ask for these things back.
Oh, they know that people don't.
Well, yes, they're used to people not, because I have never in my life, and I've worked a number of jobs now. I've been working since I was 21. I've never asked for anything back, but I've signed a lot of things.
That's right.
Wow.
And so one of the things that I want your listeners to think about is the way that you handle yourself going into the job really sets the tone. When you say, hey, HR, I need the countersigned document back, they understand you're paying attention. They understand you know your rights. They understand you're probably going to keep this document handy. And so the way they treat you is different. It's just like if you could imagine that you go to a job and one of the things that slips out during casual conversation is my brother, mother, father, whomever is a lawyer. Okay? That just comes out in casual conversation. When things go south and they're sitting around the table in the HR office deciding what to do you think they will not remember you have a lawyer in your family and think twice before they start to screw with you?
You know, that is so good. Oh.
So if you don't have a lawyer in your family,
Right.
what you need to do is do other things that convey, I have access to one.
Right.
So when you ask for a countersigned document, I might even say, hey, my lawyer's bugging me to get a countersigned document back.
Oh, that's good.
Right? It's not me. I'm not doing it. I'm not a pain in the butt. You know how lawyers are.
Right. This is par for the course.
Yeah. And so now it's, well, this lawyer cares enough to get it back, follow up, and you have access to him or her. You're sending a message.
You know what? And I may be wrong for saying this, but I'm going to keep it true. So as you're saying all this, all I'm imagining is like an older white man telling his like 30-year-old son all of these things that you're saying right now. Like all of them. Because nobody tells us this stuff. But I imagine white males tell each other these things to do, and they do them because, I mean, it's their system, it's their game, like they know it.
Well, and there's an entire body of knowledge that many of us don't have access to.
Right.
Right. And many of us, right, I don't know about your parents, but even my parents that have degrees and have had jobs, but they still, how many times have they engaged with a lawyer or the legal system? And it's
only
rare.
When, cousin Pookie, Uncle Ray Ray,
Right.
are down at Loose Sterrett.
It's a different mindset.
Right.
And
that's the only time we're like, we need money. We gotta get a lawyer because we gotta get them out. And yeah, that's the only time we think of a lawyer.
That's right.
But we've got to get out of this mindset that we only need lawyers when something adverse happens. We need to start being more proactive and being thoughtful about what we're doing, especially as we are working to climb the corporate ladder.
And if we can start having different conversations in our homes, around our dinner tables, that's a really good start. But today, if you're an adult in the workplace, you can't go back 25 years and have those conversations. You've got to be aware and start thinking strategically today.
Right. And so I encourage all of you out there listening to the next brunch, because we like to brunch, that you guys, we bring this up. Like, bring this show up. Bring up these tips. Talk about, hey, who's your attorney? Do you have an attorney? Okay, maybe we could all pool in together, and if we have to have somebody on retainer, or we can find somebody in groups of people to help us. Or if there are Black women attorneys out there who want to raise their hands and say, hello, wake up. And I mean, Mike is always here. And of course, I'm going to share your information, Mike, on the show notes and in the show. But we need to start being very strategic and proactive around how we're managing our career, not just from internal politics, but also from the standpoint of legally knowing our rights in the workplace and even outside of the workplace. And as we continue to have our side hustles, we really need to understand what those ramifications are as well when it comes to what you said earlier about, hey, your company could take your business and have a legal right to do that because you didn't know what you signed. So ladies, we need to wake up and we need to start paying attention. So a question for you, Mike, is it appropriate to talk about, because I just brought up this idea about, getting with your friends and pooling together, like, hey, can we, share counsel or cost or knowledge? Like, how do we talk about the cost of an attorney?
Yeah.
Because that's something
We don't do.
we don't. Because I think just out of fear, because I know I've paid, upwards of $5,000 for counsel at different times in my life. And for a lot of people, that's not easy to come by. Like, that's, especially if you're earlier in your career and maybe you don't make bonuses yet, and maybe you don't get signing bonuses yet, but you're on a certain track and you're getting somewhere, but in the early stages too, you need help. You need this type of help. So what advice do you have around, appropriate cost and disclosing cost, and, how do we talk about that?
Yeah. So we use cost as a barrier to access. Mm-hmm. And what we do is we actually don't know the cost. So that unknown boogeyman, we essentially make bigger than it ever would be.
Right.
That's the first problem. The second thing is that we then, if we find out the cost, we start to weigh this gamble. Mm-hmm. How much does it really matter? So I'll tell you two stories. One, client came to me, had a business proposition. They were going to invest a significant sum. I'm talking about $1.5 million.
Yep, that's significant.
That they were getting on a loan.
Oh.
And so the cost for me to review the transaction was about $3,000 to $5,000.
Okay, so that's pennies on the million.
Pennies.
Right.
But penny pinching, they decided not to have me review the documents. Not only did they lose the $1.5 million, they also probably spent $300,000 to $400,000 trying to recover it and didn't. Mm-hmm. So we're talking close to $2 million that was lost over a few $1,000s. That's story one. Story two is a different situation. Client signed an employment agreement, didn't have anyone review it, and then went off and started a new job with another company that was not a direct competitor, but was essentially a customer of that particular employer. Employer files a lawsuit. The actual legal bill for that lawsuit, for having basically no one review the paperwork when you entered the job or when you exited, that cost was about $35,000 to that individual.
Holy crap.
And ended up losing the job as part of the process.
Right. Because I have seen in my paperwork that I've signed that if somebody comes to sue us over your employment, we will terminate you.
That's right.
I have seen that language.
That's right. So one of the lawyers that I talked to years ago, he helped me actually to develop my business model. Mm-hmm. I operate on a fixed fee, flat fee basis. When you ask me how much something costs, I don't give you an hourly rate. And what he said to me, which is why I do it that way, he said, any lawyer that does what he or she does enough knows how long it takes.
True.
And so I can sit here and tell you right now, my rate to review an employment agreement or a severance agreement when you're leaving a company, $500 flat.
Okay.
And so there's no hide the ball. There's no concern about, can I discuss costs? What is the high side? What's the low side? You know, the high and low, it's the same number.
Right.
And so if you can find someone that can work with you in a very fixed, flat model that gives you comfort and predictability,
right,
that's useful. And so don't be afraid to even, before you need a lawyer, find a lawyer.
Right.
And just know who that person is. Go have lunch or grab a drink, whatever it is you want to do, so that that relationship can exist. And that way, when you need someone, you know, I've had literally someone say to me, I'm in an office. I've just been handed a document. I'm getting fired. Can I take pictures of the pages and text it to you so that you can talk me through this right now? It doesn't need to be a formal communication between you and me where you transfer the document and faxing and scanning it. Text is fine, right? We got to get the job done.
Right.
And so find someone who's able and willing to dig in and get the job done in the moment. at a price that makes sense and hopefully is predictable for
Right.
you.
What I love what you said there, and it's happened to me. The last time I needed legal counsel, my cousin referred me to somebody. And so instead of me building the relationship, it was because I was in an immediate situation, right?
Right.
And so I didn't build a relationship. I was relying on a relationship of a relationship. And what you just said hit home for me, because that was another mistake I made in that process, is that it wasn't somebody I personally had a relationship with. So months down the road, this situation at this juncture did not work out in my favor because I did not have the right relationship with this person. So building a relationship before you need it,
That's right.
and before you need it is key. In the show notes online, TrillMBA.com, I will bullet point all of these nuggets throughout this show because there's so many. Like, I'm over here having Oprah aha moments and hallelujah Jesus and Lord, why didn't you tell me this before? Because there is nobody to tell me this. So I'm learning a lot today myself. So I appreciate you coming and sharing all these insights with me and with my listeners, because these things are so critical. Because, there's a phrase that says, if it doesn't make dollars, it doesn't make sense. And there's so many things that, because money's not right in front of our face, that we think don't have financial ramifications and will cost us a lot on the back end.
Maybe more than what you were bargaining and negotiating for.
Exactly. And so the biggest aha I'm having right now in this moment is to find an attorney that I can build a relationship with. Now, the great thing is my line sisters, I have 7 line sisters, and of the 8 of us, 3 of them are attorneys. But the thing is, you hate to rely on your friends, but I have now had to rely on one of my line sisters now to help me with the situation that I'm in. And I think about it and I'm like, but you don't necessarily want to have to do that. And, you want it to be somebody that you can have a professional relationship with, even though they do know very personal things about you because of the nature of the relationship. You still want to establish that early on. So now, in addition to, my friends being attorneys, I will be using them to find the right person for me and, my business going forward. I know I need to do that now as I continue to move on in my career, wherever it's going at this point.
Yeah, the last thing you want to do is be in a position where you're scouring the internet for a contact at the last minute.
Yes, that it's painful, which is why I called my cousin and she was like, oh, I have an attorney for you. Listen, y'all, unless you build a relationship with that person yourself, don't do it.
And the truth is, not every lawyer is for everybody.
Exactly.
Right? And your style and your needs may not match any other lawyers. And so figure that out.
Yes.
Right? Because I will say this, the way that your lawyer communicates on your behalf speaks a lot about you.
Right.
So that's the other thing, is if you've got someone who's not communicating in a way that reflects positively on you, you've got a lawyer who perhaps is going to, and I've seen this, I've gotten a document back that I've drafted for an employer, and the employee took it to a lawyer and had that lawyer revise it. And I looked at it and I said, I have no idea who looked at this, but we are not doing any of these things that you've proposed. And I'm not sure you understand what's going on here. And so that does not look favorably upon that person who picked that lawyer.
Right. Exactly. Oh, Jesus. Okay. Now that we've cleared up these myths, I just want to make sure people understand that build this relationship, build it now while you quote unquote don't need it, and make sure that you have this person lock in step with you along the way. So when you're looking for opportunities or you have an opportunity with your business, let that person know, hey, this is what I'm up to. It could be like once a year, right?
And like I said, not even. I have people call me years and years later, but that's just fine. And I don't necessarily hear from them, right? I may get a Christmas card and
Well,
that's it.
nice.
But what's really important is that we had a positive experience together. We know how one another works best, and it works well as a pair. And so we're ready to take on this next challenge.
Awesome. And then when you get an offer or you get a new client, if you have a side hustle or you're a full-time business owner, whenever you're doing any of these transactional things, when you have to sign documents, that person, like, you shouldn't even sign anything. You should just automatically be able to send it to that person, and you should already know what that's going to cost. You should already anticipate all of that.
That's right. And you should be comfortable that there's value coming back.
Right.
Right. And so, for example, you've got your small business and it's just a weekend thing and it only makes a few $1,000s a year. It's not a big business. Well, if you've got a lawyer who's going to try to essentially hammer you with fees, they're just eating away at your margin.
Right.
And so a lot of people will lean on the internet. I found a contract on the internet.
I'm putting my head down right now in shame. I shouldn't, but I am, because I have done this.
A lot of people have.
And what is it? Zoom.com or
something? LegalZoom.
Yeah.
And so I won't speak to whether or not LegalZoom is right for any individual situation, but I will say you don't get the same ability to pick a lawyer, engage with that lawyer, and figure out if that's the right person for you.
But listen, even LegalZoom tells you to go to an attorney.
That's right. They understand that there's no substitute. And the face-to-face isn't the important part. It's the communication, however it can happen.
Right.
Get somebody in your corner. And then over the course of time, one of the things that I do for my business clients is every time a problem comes up, once the problem is resolved, we take a look at the contracts that are being used and we ask, can we make this better in light of the experience you just had?
Yeah, that's key. That's important. And I think that's something that we don't think about, because we'll have an experience, we'll quickly find somebody to fix it right there, and then we move on and probably make the same mistake again until we finally hit our head enough times to wake up. So instead of doing that, ladies, let's be proactive. I think that should be the theme of the show. Be proactive. So before things go awry, when things are good, I think one thing that people don't think about is, let's say I'm getting promoted at my job. What should we be doing then?
So if I'm advising a business client, I'd say refresh your employment agreement. If I'm advising an employee, I would say the same exact thing.
Right.
All right. So everybody gets the same advice, which is figure out, is the old agreement sufficient to cover the new reality?
That's fair. Yeah, because a lot of times you get a promotion that's more responsibility, more work. And I don't even know if you necessarily sign.
You often don't. Yeah.
It's just this verbal, like, hey, you're going to get promoted. You've done a good job. And so that feels good. But I think we forget in the process, like, hey, make sure you covering your butt,
Because HR has a bunch of paperwork about this transaction.
Right.
But you don't.
Right. Totally. That's scary. Should we be asking for our files every year from HR? Or?
I would say that's probably overkill.
Okay.
You don't need your file every year. And to be clear, in most states, you do not have an absolute right to receive it to begin with.
True.
So rather than asking for your file, keep everything that comes your way. You get a written warning, and I see this often where people say, well, I refuse to sign. let me just let you in on a little secret that's no secret at all. Your signature doesn't change whether or not you got a written warning.
Okay.
All right. And so you haven't changed the outcome other than you have taken a negative moment and you've made it even more so.
Oh. So you saying we should sign?
Sign away.
Because my mom always said, don't sign shit.
Well,
of course, my mom only made it through high school. So
right. It's a false notion that your lack of a signature has any impact whatsoever. As an attorney that's representing the company, I'm going to put it in front of you and I'm going to say, did you receive this? And you're going to say yes. And I'm going to say, did you sign it? And you're going to say no. And I'm going to say, why not? And you're going to say, because it wasn't accurate. And I'm going to then point you to the sentence that says right above your signature that you didn't sign, by signing this, I do not agree that this is accurate. I'm only signing that I received it. So now you look like the most difficult person out there. And guess what? I'm representing the employer. I want to paint you as a difficult employee.
Right.
Thanks for the help.
Wow. Reading is fundamental. And if you don't feel like reading, this is where that relationship comes into play. God, y'all. Ooh, I'm just so happy about this show. So that's another good nugget. Read and sign. Because it doesn't negate the fact that you're getting this negative information.
That's right. You can only make it better by signing it and addressing it and moving on. You're going to make it worse by being the arms folded.
Right.
I refuse to participate.
Wow. And that's something, I mean, did you hear that growing up? Don't sign shit like that.
Oh, yeah. I remember the first time that I saw that it wasn't signed as an attorney and reading the language above it and thinking, well, that seems kind of silly.
Right.
Why are we having this fight over signing it? Because they just hand it to a witness that says, I witnessed that you refused to sign. And so the effect is the same from the employer's side.
Right.
I have proof that you received it. The effect is not the same from your side.
Right.
You have lost whatever goodwill you might have tried to build exiting that difficult moment.
Wow. See, ladies, that's why we gotta be strategic. So speaking, and that's a don't. So don't not sign it, but make sure you read what you're signing. And even before you sign it, I think in that moment, do you have a right to say, hey, this seems like a formal document. I would like to send this to my attorney before I sign it.
You can certainly ask. You're a number of options, right? You're sitting in the room, the documents are slid across the table, and you have to make a decision. First thing, ask for a copy for your records.
Mm-hmm.
Second thing, ask for a day to review it before you sign.
Okay.
Third thing, ask for an opportunity to provide a written response.
Ah, okay. That is a lot better. That opportunity to have a written response filed with the document.
And they don't have to give you that opportunity.
Okay.
But they can't stop you from sending it anyway.
Okay. So if I do write a response and I send it and ask for it to be placed in my file, are they obligated to place that in my employee file?
No, but
okay.
But work through the scenario to the end. Right? This is what I always tell people is don't stop at that question. Work all the way to the end. So assume you've written it, assume you email it, assume they refuse to put it in your file. Assume we're now in court and they produced your file without it.
Okay.
And I have the email where they received it. Now who's being the childish, immature one with their arms crossed and refusing to participate?
Ah. Did you get that, ladies? Gotta be smart. So what are some other like do's and don'ts? So one thing I always tell people that I'm either coaching through a difficult situation or, you know, we're talking through these scenarios, trying to help each other because we're not bright enough to get an attorney, but now we are. But I always tell people, document. But I don't think I really know what is good documentation versus what is documentation that's not helpful.
Yeah, that's a hard question. And I will tell you that HR professionals get training on that question and they still don't do it well. So what chance do you have?
Right.
Well, here's the chance you have. Keep some kind of a diary journal for work-related issues.
Okay.
It should not contain personal items. Okay?
What's define personal items?
Issues with your family, issues with your partner at home, issues with financial struggles, whatever you're dealing with, you need a work journal. When things are going poorly, you need a work journal. And do not include commentary. All right? No, I hate that BIT. None of that's helpful.
Okay.
All of the emotional responses are to your detriment.
Okay.
What I want, old school, I used to watch TV as a little kid, and there was that show Dragnet, and there was just the facts. That's all I want. I want just the facts. I want the date, I want the time, and I want what happened and who was present.
Okay.
Because I'm not going to use that as proof that it occurred.
Right.
I'm going to use it to jog your memory about the sequence and what happened.
Okay.
And so then the jury is going to see it and they'll use it as confirmation, because juries will accept what's in writing. Even from the same person, they will accept the writing over what the person says.
Okay.
So that's what it's useful for.
Okay.
But all of the other things that you put in there that might be venting are to your detriment.
Okay. So no venting, date, time, people, place, and just bullet point what actually happened, not how you feel about it. Doesn't matter how you feel about it. You can be angry all you want to. That's not what's important. What's important is this person said XYZ to me. I said XYZ, verbatims, right?
As best you can recall.
As best you can recall, and that's it.
That's it. That's
All right.
it. Leave the rest to litigation.
Okay.
We can fill in the gaps.
Okay. And what about tape recording conversations? Now, I did my research on this a long time ago. In Texas, as long as you're in the room, okay, so you're going to tell me if I'm wrong or not, but as long as you're in the room and you're a part of that conversation, you can tape record it, but that's not true for every state.
Well, so here's what in my do's and don'ts.
Yes.
My do is follow state laws and workplace rules on recording devices.
I don't know what workplace rules are. Do workplaces have these rules?
Absolutely. And with the increasing availability of a recording device like a phone, workplace rules are often set up to prohibit that kind of conduct. So you've got to be clear.
Okay.
Yes, you complied with the state law.
Okay.
No, you did not comply with workplace rules.
Oh.
And so you're fired.
Oh. Okay. So what if you get a client that did record some conversations?
Oh, I want to listen to it.
Okay.
Yeah. Let me be clear. Not to say that everyone should run around recording everything. I don't believe in that.
Right.
But if it's recorded, it's already occurred. What I don't do, so in my do's, I say follow state laws and workplace rules. What I say don't do is don't go in there with the bad sort of question that you're trying to get a confession on something that happened a day or two ago and you didn't get it recorded. And so it's like, hey, Steve, do you remember that time you called me a... No. Okay.
Right.
Because juries also appreciate that you knew you were recording,
right,
and they did not know that you were recording. Right. And so being more candid about what you're doing, if you're going to record, don't throw setups into the mix.
Okay. No, I've just always told people, hey, they call you in the office. You don't know what you're about to be hit with. We got these phones now. I say in Texas, and I have a phone that has a cover, so you can't see that it's recording, and I can just come in and I just have my phone and sit it down, and y'all say whatever y'all gonna say. I don't know what you're gonna say. I don't know what I'm gonna say, but I just have the conversation, and for me, it's just backup. And I only do that when I'm in an adverse situation. I don't go around recording every day, everything. Like, first of all, I don't even have that much room in my phone. Second of all, I'm not that paranoid. And third of all, that's a waste of time and energy. But when I do find myself in a sticky situation and I stop trusting what's happening in the office, that's when my spidey senses go up, and it just becomes a sense of protection for me. But I never thought to look at what the workplace rules were.
Yeah, you really want to do that. Even if, now, to be clear, if you're getting terminated and so you're in the termination conversation and the workplace rules say don't record, well, the worst thing they can do to you, they're already doing to you.
Right.
So there's a certain amount of what I would call limited exposure there. But in a day-to-day scenario, you really want to pay attention to making sure that you follow the workplace rules.
Okay, so let's say I didn't follow the workplace rules.
All right.
And down the line, like you said, think ahead. Down the line, I did break the rules, but I'm actually like being harassed or being discriminated against, or, you know, my manager is treating me really bad and like cursing at me and yelling at me and acting a plumb fool with me. Like, is there any harm in just having those recordings when you get down the line?
There's no harm to having the recording, other than people will sometimes look at you with a little bit of suspicion, right? And they'll see you as someone who's not trustworthy. But the reality is, once you have the actual recording, we can always characterize the effort as protective.
Okay.
Right? Not being sneaky, but attempting to be protective of your own self.
Yes, because a lot of times it's your word against theirs, especially if you go to HR or you're trying to defend yourself. And it's like, I tell people all the time, HR is not your friend as an employee. They're just not. They're human resources. They're a function to protect the company when it comes to the human capital of the company. That's it. And so if you think that you're going to go into HR and get some type of remedy from the mistreatment that's happening to you, no. What they're going to do is say, well, what do you want to do about it? What do you propose we do about it? Or they start saying stuff like that, or maybe there's a remedy that we can both come up with, which means now they might be talking about paying you to leave.
Well, I don't want to paint HR with that broad of a brush.
Okay, you don't.
But
I will.
But here's what I will say.
But Mike didn't.
Here's what I will say. You know when you have an effective HR person at the helm.
Right.
And you know when you don't.
Right.
And so when you do, that person has direct access to someone that matters. C-suite, they're in the C-suite, and that person is not afraid to exercise their power and authority. And they probably have a very good and close working relationship with internal or external counsel. Mm-hmm. That kind of HR person, you present a real issue, and they have the ability to say, Johnny's got to go. We don't have that here.
Right.
Now, a lot of HR people, they end up without that power. They end up without that access, and they end up looking to protect their job. Mm-hmm. And their job is to make you quiet. Mm-hmm. And so I would agree that where HR people are not empowered and where HR people are not taking the initiative to really, truly protect the company.
Right.
Because to me, sweeping it under the rug is not protecting the company. It's actually protecting your job.
Right.
In an isolated way as an HR person. That's all you're really protecting. But those people, you understand who they are, you understand where they are, and you have to treat them differently.
Right. I can tell you right now, the vast majority of stories I hear from my listeners, my own network of women, it's the latter. It's usually because you're the squeaky wheel and you're trying to change something, and you become the problem because you brought up the problem. And even if you come with solutions in a situation where you are being mistreated, you now are seen as the problem, especially as a person that's like what's the term that they call us? We're protected class of employee. And so now everything becomes like, ooh, whoa. And there's always a big to do in all the situations that, I've been told about or heard of. And it always becomes it's easier to push you out of the organization, especially when you're at lower levels and it's somebody in higher levels that's mistreating you. It's easier to push you out the organization quietly than to actually try to manage and change the culture of the organization.
So I started off this conversation talking about the power dynamic in a negotiation with your employer over your employment agreement. That power dynamic never goes away. It can change, but it never goes away. And so when you want changes to occur in the workplace, the first question is, how badly do I need to keep you? Right? And so if John is harassing Jane, John is a big producer of revenue and Jane is in, accounting.
Right.
I'm going to start making business decisions about what do I need for my company to be successful. And John is more important to the overall success than Jane. And that's what happens to Jane. She gets pushed out because I can replace Jane with an ad in the paper or on the internet or what have you. I can't replace John. Now, that is the absolute incorrect way legally to address the issue.
Right.
But that is often what happens in organizations where John and Jane are at different levels or have different productivity.
So I'm very passionate about this because so much has happened to me personally in my career. I hear so much now, especially doing this podcast, and people come to me and they tell me their stories and how they're struggling with these things, and that what you just described so eloquently is definitely what we're going through. It's a devaluation of us as human beings because in their minds, this higher up, oftentimes white male, is more important to the organization. And so they can terrorize. It is mental terrorizing for a lot of people out there. And the only recourse we have is really to just leave. But I always tell people, hey, make sure they paid you to come, make sure they pay you to leave.
At the end of the day, if you have to bail out in order to protect yourself and your sanity, make sure that you've got all these other things in place,
right?
That you've documented, that you've created for yourself a record,
right?
And not just a squeaky wheel record, but a record of legitimate complaints,
right?
And I will say this, one thing that we have to stop doing is using the term hostile work environment to mean something other than what it means legally. Because
what does it mean legally?
On its face, hostile work environment is just that. I go to work, the environment is hostile. Okay, that is not how lawyers use it. That is not how courts understand it.
Okay.
A true hostile work environment is that, but it's based upon a protected category.
Right.
And so if you go to work and your boss is a jerk, you do not have a hostile work environment claim.
Okay.
If you go to work and your boss is a jerk to all the women, you do.
Right.
And so be very clear on what it is that you're complaining about, because that's going to turn you into a squeaky wheel.
Okay.
And then you're undermining your own efforts.
Right. So it really is about, if you're going to fight, it really is about finding the patterns of bad behavior of that person and pointing that out.
You need that.
Right.
You need that. You need to be able to tell a compelling story about what's happening and why you are being targeted.
Okay.
It's not enough to say that you didn't get the job or you didn't get the promotion or your salary is too low. Courts and frankly, lawyers representing employees are looking for evidence that associates that wrongful act with a particular category that you belong to.
Okay. Wow. I'm gonna have to lay down after this conversation. It's a lot. I really appreciate you for coming and sharing all these nuggets with us. Is there any one last burning thing that we didn't talk about today that you would want the listeners to know?
The one thing that I would say, and particularly because of the demographic of your audience, women of color and Black women in particular, there is this myth of the angry Black woman and the loud Black woman that has become part of our culture as a community in America. Right. And what happens in the workplace is everything that you do that furthers that sort of myth or that archetype of a woman is going to then be used against you. One of the hardest things for women of any color to do is to be assertive and to be clear in their messaging without being labeled a bitch or any other term like that.
Right.
So practicing your tone, practicing how you measure and deliver difficult messages.
Right.
All right. It helps you in your personal life. It helps you in your professional life to be able to deliver difficult news in a way that is constructive.
Right.
Because time and again, emails pop up or allegations are made about the way that someone behaved or the way they presented, and it fits a stereotype.
Right.
And so people who are not part of that community buy it and assume that it's inappropriate, and now you've got an uphill battle.
Right. Even when the person is coming for you.
That's right.
You know, you can't turn into an Atlanta housewife and say, don't come for me, I didn't send for you. Like, that's not going to help you here.
You have just ruined all of the goodwill you've built over X number of years at that job.
And I think what makes me angry, what gets me, is that how am I supposed to defend myself?
You don't defend yourself in the moment of the attack. You defend yourself by being unassailable. And you don't become unassailable because you're perfect at work. You become unassailable because you know your rights, you have the ability to enforce them, and you're smart enough to manage the system to do it. And if they know that about you, they don't come for you.
Well, on that note, Mike, I want to thank you for coming here today. Listen, if you need to know your rights or you have a specific legal situation, you can reach Mike, and it doesn't matter what state you're in.
That's right. At least to begin with, we can talk to anybody.
Right. You can reach Mike at www.colesfirm.com. That's COLESFIRM.com. And you can also connect with Mike on LinkedIn. You can find him Mike Coles. And I would just want to thank you so much for coming today. I have learned so much that I did not know, and I thought I knew a lot. But good Google doesn't tell you everything. But ladies, it's so important for us to protect ourselves, be proactive about it, build a relationship with legal counsel so that you can go into corporate America confident that, again, you don't have to fight in the moment to defend yourself. You know your rights and you play the game and you will win. So if you need some help or advice on a specific work situation, now not legal, I'm not a lawyer, but a work situation, feel free to email me at ask@trilmba.com. I'm happy to either answer your question or connect you to the right person if I don't know the answer. Again, that email is ask@trilmba.com. Also, If you're struggling to figure out strategically what to do with your career, you can set up time with me on my website, trillmba.com/coaching. If you go to the coaching site, you can schedule a free 30-minute consultation with me, and we can strategize and talk through what next steps would be. And if you need further coaching, we can talk about that as well. So use us as resources. We are here to help you. You can make it, whether it's in corporate America and you're trying to get to the C-suite, or if you're side hustling, starting your own business, resources are here to help. So reach out, and until next week, keep it trill, y'all. The Trill MBA Show is a Fair World Corp LLC production, executive produced by Felicia and Rose Enuha. Music is Kick Push by Ryan Little. Keep it trill every day, y'all.